get started with the third unit in the intro course. It's chapters 7, 8, and 9, and it covers legal research and writing. Just keep in mind that you will take 2 courses of legal research and writing, so this is really just an overview of what we'll cover in those 2 semesters. So trying to cram 2 semesters into 3 chapters within intro. So just as a little introduction, legal research, chapter 7 is on legal research, and it is probably one of the biggest tasks that paralegals work on during their career. Research and writing are a huge piece of the job and are a huge piece of each of the courses that you take in the program. And the ability to conduct research is something, being able to do it efficiently is something that is valued about a good paralegal. And it is essential to learn how to begin, how to complete research. Probably the first big step is just determining what is the issue that you are being tasked to research. Usually client comes in the office and they are having some type of problem, and attorney is asking you, if it's something they're not familiar with, to go and conduct research and bring back a internal memo, which we'll talk about in chapter 9. But you have to, sometimes it's about something that you just have no idea, no previous experience with, and you've got to do some background research to start with, making sure that you understand what the issue is. And from there, you begin to look for ways that you can define what the problem is or what the issue is. And I advanced a slide before I needed to, and it won't let me go back. So you have to think about what is the issue. You want to look at who are the parties involved. Who's the plaintiff, who's the defendant, or if it's a criminal case, who's the defendant, who's the prosecution. What are the places and things that are involved in this problem that might, or this issue, that is going to be the basis for a cause of action. What defenses might the other side have? What is their take on the problem, and what type of relief is being sought? Meaning, are we asking for money damages? Is somebody asking for someone to stop doing something? And so as you are beginning to do your research, you tend to, the way that the textbook presents this is case research first and then statute. I have to say that many times attorneys tend to look for a statute first. There's some reasons why. The number one reason being that if there is a statute, it will point you to cases and to other research. So sometimes it's easier to start in statutes. It's also something that most attorneys are going to have a set of their code, a set of their statutes right there behind their desk. And so it's just the easiest place to start. But the text starts in case law. So when you are doing case law research, you are looking for cases that are on point. Okay, what that means, and that's something that's kind of a theoretical concept that students who are just getting started in learning about the law, that's something that's It's kind of difficult to conceptualize, but it's a past case that has similar factual circumstances and similar issues to what our client's problem is. Now, the problem is we want to find the perfect case on point, the case that is just like ours, so we can predict what the court's going to do. Well, the problem is very rarely do you have what that would be called a case on all fours. Either the parties are the same or they have the same standing, the circumstances materially the same, issue exactly the same, remedy is of the same kind. That very rarely happens. You're going to find cases that are similar, but and be cases on point, but not necessarily always something on all fours. So don't think you're always going to find just that perfect case. Part of this process is your learning the ability to analyze other cases and determine how you can draw similarities between your case, your client's issue, and the cases you found in your research. You also want to pay attention that you're looking for binding authority, meaning you want to find a court that has binding on the court where you will be trying this particular case, so that it will have, it will serve as precedent. Okay, so finding relevant cases. We talked about this maybe in chapter 4. There's 2 basic types of legal resources. You've got your primary sources of law, okay, our Constitution, our statutes, our cases, and our administrative rules and regs. And then you have secondary sources of law that explain that primary source of law. And the great thing about secondary sources, not only do they explain the law to us, they help us locate primary law, because they usually have some type of annotation, references to primary law. When we're talking about secondary sources, we're talking about encyclopedias, law review articles, ALR annotations, which ALR stands for American Law Reports, and those are a great source for finding primary sources. Okay, so the next slide has some screenshots, some pictures of one, and there's a glare, so it's not the best picture, but of Legal Encyclopedia. The index for Corpus Juris Secundum is the first picture, and then the middle picture is actually one of the volumes, and then the third is inside one of the sections. So if you've ever worked with an encyclopedia before, legal encyclopedias work the same way. The only difference is you might not just in the beginning have the exact keywords, and you may need to go to an index. That's something else that you're going to find as you're doing legal research and print materials, is that you need to become proficient in using an index. For those of us who have been researching for a while and learned to research prior to the internet, we are used to working in index or in a index or in indices, but students who have grown up with the internet, it's a little bit more challenging to learn how to use an index, but it's something that you need to become proficient in. Ways to find cases, as I said, you can use secondary sources that will point you in the direction of primary sources, but there's also this tool, it's called a finding tool That's kind of the general description for this. It's called a case digest, and it provides you, it's basically a big index to reporters, which is where the cases are published. So it's just a big index to the cases, and they are, for the most part, they are published by West, and they follow what West calls the West key number system. The West brothers, and we'll talk about this in research and writing, they were extremely innovative, and they created the system. The West brothers actually started publishing in the mid to late 1800s, and they created this West key number system where they took every single possible topic in the law, and they assigned a number, a topic, and a key number, so that there's these big groups of topics and then subtopics, but they all have a topic and a number assigned to them. And this system is how these case digests are organized. A lot of this is not going to, you're not going to be able to visualize it until we are actually in the library and I can show you these resources, and that will come in research and writing. So there are digests for every set of reporters. And then this next screen is some screenshots of the digest. So the first picture is a picture of the spine of the index to the digest, and this is the Georgia Digest. And then you are in the middle is inside that descriptive word index. You break your client's problem down into what we call descriptive words, and you then go to the index and look for your descriptive words, and then they will send you to, you'll see here there are topics and then a key number. So this topic is about landlord and tenants, and it is the number is 180.5. And we'll talk more about the West key number system as we go through research and writing. But and then the third picture is from the actual within the digest, where it has you take this topic and key number, you go to, and this would have been the topic animal, key number 50 or 51 actually. You go and look, and it will have a summary of a case that has been decided in that jurisdiction about that topic. Okay, so I mentioned American Law Reports, ALR. Those are great resources for explaining about cases and explaining particular cases and finding references to other resources on that same topic. Some other secondary resources, you've talked about some of them in your, or you've read about them in 1L, treatises and hornbooks, restatements of the law, which we talked about in, I believe, chapter 6, and legal periodicals like law review articles. Here are some pictures of a couple of resources. Redfern is a treatise and a form book and a practice guide. So it's kind of 3 resources rolled into one. Any attorney that works in wills and trust, does probate in Georgia, is going to have a set of these texts They're called Redfern. Nobody calls them wills in administration in Georgia. They just call it Redfern because that was the original editor. And if you practice in that area, you're going to have a set of those in your office. The other is a picture of Black's Law Dictionary, which is something you want to go ahead and become familiar with, because you always, especially when you're starting out, you're going to find lots of words when you're doing research, when you're reading cases, looking at statutes, that you don't know what the words mean, and you need to look them up. And you just need to go ahead and accept that, and don't worry about having, even if you have to look up every other word or every word, until you become more familiar with the language. That's just what you have to do. So, some tips for effective legal research. Know the legal issue that you're going to be researching. Make sure you understand the language of the issue. That's one of the reasons why you may need to do a little background research, and make sure that you have a good understanding of that area of law. Be aware, legal research is very circular, in that once you find something, you're going to keep seeing references to the same things. And that's kind of the idea. That's how you know when you are, you found everything that you possibly can about a particular topic. Always keep a list or a notes about where you've been, because it's very frustrating to get to, after you've read, let's say, 10 cases, and you realize that the first case you read is the one that was the closest to what our client's issue is, but you can't remember the name of it. That's very frustrating. So make sure you keep notes of where you've been and where you want to go in your research. Always make sure that you are aware of the time frame of your research. Especially if you've got a writing piece attached to it, make sure that you're pacing and following the timeline that you've established. Always make sure that the cases and the statutes that you're relying on are still good law. That's what we call to shepherdize. And we'll talk more about that, but Shepard's was the first tool. Westlaw now has a similar tool, but it was the first tool that was used to make sure that cases had not been overturned or statutes haven't been repealed. So state court decisions and reporters. So first of all, cases, opinions get published in what are called reporters, okay? And they get published chronologically, okay? So court decides a case about a criminal case on Monday, and Tuesday they decide a case about contract law, and Wednesday they decide a case about a family law issue, and they get printed in the order that they're decided, okay? So what's problematic about that is, unless you know the day that an opinion was released, published, it's going to be difficult to find the case. There's not an index for the reporters. That's why we have these, what we just looked at, these digests that serve as the index for the reporters. And usually every court has a reporter that their cases get published in, okay? Not every court, but but for the most part. So in Georgia, if a case is decided in the Georgia Court of Appeals, it gets published in the Georgia Appeals Reporter. Okay, and if it's decided by the Supreme Court, then it's just the Georgia Reporter. Okay, but another way that the West brothers were so innovative, they thought that, you know, attorneys might need to see cases from sister or adjacent courts, and so they created the concept of regional reporters. They decided to put together cases from multiple jurisdictions, because an attorney, you know, maybe there isn't a case from Georgia about a particular issue, but there might be one from South Carolina or Florida. And so the West brothers created these regional reporters that would cover multiple jurisdictions. We're in the Southeastern Reporter, and these became so popular that some states discontinued the use of their state reporters. We still have ours, but many states have discontinued it. Another thing we have to think about is citation format. We talked previously about the pieces of a citation, the case name, then the volume, the reporter, the page, when it was decided, and there is a particular format for every piece of legal research that you might use, and those rules are laid out in, there's actually two main citation manuals that we use. One is the Blue Book, which was the original, and then ALWD, which is said Aldwood citation manual. Usually Blue Book is the standard. If a court does not state in their court rules what citation manual to use, they are assuming that you are to use Blue Book. That's what the Supreme Court does. It's a little bit stuffy. It tends to be now very academically focused, in that if you're, you know, publishing academic things in the law, and Aldwood has become more practical and for practical use. So keep that in mind. Also, the fact that we have these state reporters and regional reporters, that means that some cases are being published in more than one reporter. And so that means they have what are called parallel citations. Or think about it as an address. This case gets published in a couple of different places, so it has a citation for each of those places. Those are called parallel citations. Federal court decisions. District court decisions get published in a reporter called the Federal Supplement. Courts of Appeals decisions are published in the Federal Reporter. Those are both unofficial reporters, because the court actually will publish their own version as well, which is the official. And each of the district courts also have a bankruptcy reporter. And they are also published online and in Lexis and Westlaw. The United States Supreme Court decisions are published in actually 3 different reporters, so they would have 3 citations. The United States reports, which is the official version. It originally comes out in a slip opinion, and we'll talk more about what that means in research and writing. Then they are also published in the Supreme Court Reporter and the lawyer's edition of the Supreme Court Report. So 3 different places. As 3 sides. Okay, this is the Georgia cases from the Southeastern Reporter second series. It is the regional reporter, but it is only the Georgia cases. Actually, the Southeastern Reporter covers Georgia, South Carolina, North Carolina, and Virginia, and West Virginia. But our library just bought the Georgia cases to the Southeastern Reporter. So this is what a case looks like, okay? And let's talk about each of the pieces of a case. I know this is going to be very small on your screen, but you have the components of a case. You have the case name. You'll see here in the all caps are the parties. So that's the case name. It'd be People v. Meyer. You have the citation, the place where they are published. Actually, there's a parallel citation here, 2 citations. Then you have the names of the attorneys involved. Excuse me, there's right here. Those are the names of the attorneys involved, and the judge who authors the opinion. You are going to see the docket number. It's so hard when it's so small, but there's your docket number. You have, sometimes there'll be 2 dates, when it was heard or argued before the court, and then when it was decided, or if a rehearing was denied. There is a syllabus in certain, depending on where you're viewing the case. That's this right here, and it's just a short summary of the case. The issue with it is that it is publisher content, so it's not something you can quote from. It is only to help you understand about the case, and it's not from the court. It also has, you'll see these numbers, 1, 2, 3, 4. Those are head notes, and that means, let's see, there are 8 of them. That means there are 8 rules of law that are discussed in this case. Okay, and so each of them is summarized here into a head note, and because this is a West publication, it has a topic and a key number. So that means you could go look at criminal law, and I can't see what number that is, no matter whether you were in Georgia or California or New York, and it would be the same topic. Okay, so there are 8 points of law in this case. They're summarized here in what are called head notes. These are the names of the attorneys involved, the name of the judge, and then you don't get into the actual piece of the opinion until you get to the judge's name, and that's where the judge starts talking. So this is in a West Reporter. Okay, so this is how it's structured in the Reporter. This is what it looks like, and actually that's a regional reporter. This is what it looks like in the official United States reports from the United States Supreme Court. This is how it looks in there. So they can look a little bit different, but they have the same information. Okay. Remember, we also talked about the fact that the judges can draft several different types of opinions. Usually you're reading the majority opinion. That means a majority of ever how many judges are on that court have agreed, and someone has been assigned to write the opinion. But sometimes you have concurring, where a concurring opinion where one or more judges agree with the outcome of what the majority has said, but they do it for a different reason. Or if you have a plurality, if you had 9 judges, 3 decided the case in favor of the plaintiff because, or the appellant because of A, and 3 because of B, and 3 because of C. Those are plurality opinions. They all come to the same conclusion, but for different reasons. Dissenting is if one or more of the attorneys, of the judges disagree with what the majority has decided, and they feel strongly enough that they want to write an opinion about it. And sometimes you have unanimous opinions, rarely, but sometimes you do. So when you're analyzing case law in your research, you want to look for guideposts in the opinion that direct you. I don't know why I keep saying that. Judges are, at least if they're good writers, and remember, they are not all good writers, but they try to give you clues. They try to give you hints about where they're going and using certain language. And courts love tests. They like to establish tests so that they can say, okay, the first part or the first prong of this test is this, and walk you through it. So they like, or they try to give you direction. Okay. One of the things that law students do is brief cases. We don't do a lot of it in the program, but we do some. And basically, briefing cases is just about summarizing a case, breaking it down to the most essential elements. And because, as I said, not all judges are good writers, and so sometimes there's a lot of superfluous information, and you've got to boil it down to the most important. And we do this by briefing cases. Now, most of the time when you brief cases, it's for your own personal use. If you were in law school, you brief all the cases that you read in preparation for class and being called on in class. But in practice, in the practical world, you are never going to show those briefs to anybody. Of course, you're going to have assignments where you have to show some to me, but in reality, when you're out working, you won't. They're for your own personal use to help you organize your thoughts about a particular case. But case briefs usually have, and these are just the basic pieces, the citation, the facts about the case, the important, what we call determinative facts, the facts that if we changed would change the outcome of the case, the procedural posture, how did the case get to this court, what is the issue, and there could be more than one, what's the court's answer or decision with regard to that issue, just a short answer, because then you're going to go into, in the reasoning, application, analysis section, you're going to go into more detail about why the court decided what they did. And then the holding, did they affirm, did they reverse, did they remand it back to the lower court? And in this analysis section of a case brief, you follow, or you should follow, some organization And probably the most standard theory out there is called IRAC. Now, IRAC's only been around, or the acronym's only been around probably 20 years. When I was in law school, we didn't know about IRAC. It's what we were doing, our analysis, but nobody had put a name to it. You isolate the issue, look at the rule of law, apply that rule of law to the particular facts, and come up with a conclusion. IRAC is issue, rule, analysis, or application, conclusion. But different lawyers have different preferences for what they might call it. I've seen CRAC, CCRAC, FERAC, lots of different acronyms, but the bottom line is you're doing the same thing. You're finding out what the issue is, determining what the rule of law is, whether it's a case or a statute that governs, applying it to the facts of the case, and coming up with a conclusion. Some other pieces of research that you might do, you might be having to research constitutional law, whether it's a state constitution or federal constitution. Most of the time you can easily locate those documents. As I said earlier, statutory research is probably where most attorneys start, okay? Simply because, like I said, we tend to have a copy of the code in our offices. Okay, what does the code mean? Well, statutes, both at the federal and the state level, get published chronologically first. They're called, at that time, session laws. And they are published chronologically, and thus it makes it difficult, if the legislature has on Monday passed a law about A, and then Tuesday passed a law about B, and Wednesday passed a law about C. Well, unless you know the day they decided they passed a certain law, it makes it difficult to find it. And so legislatures have determined that the best way to look at or find statutes is by codifying or codifying the law. So taking that chronological statutes and grouping them together by topic, and that's to codify the law. And once they do that, then they publish them according to those topics. Okay? And they are, the United States Code has the federal statutes, the codification of the federal statutes. And that's the official code. You also have the USCA, which is the United States Code Annotated, and the USCS, which is the United States Code Service. Those are unofficial codes, but they are unofficial codes, but they're great because they are annotated, meaning that there are summaries after each statute that point you to cases that have been decided based on that particular statute. And by getting those, you are beginning to find more resources related to a particular statute. Okay, so when you are reading statutes, you first want to read it, look at the language, then you're going to move into an interpretation of what those words mean. Now, sometimes the words of the statute aren't necessarily clear, and we have to go and do a little bit more research. And that research, might be trying to find out, well, why was this statute enacted? What were some of the discussions that were had in the committees, the legislative committees, and on the floor about passing this statute? Sometimes you have to go look at that, and it's called legislative history, to find out what the legislature intended for this statute, what purpose it was intended for. You always want to look to see what's the date, the effective date for the statute, when did it go into effect, who are the class of parties that are affected or who it applies to, what's the type of conduct that's being regulated by the statute, and the circumstances in which that conduct is prohibited or required or permitted, whatever the case may be. So this next is a copy of a statute. It's a Georgia statute, OCGA, the official code of Georgia annotated, and it's section 19-5-1, and it's about divorce. So that's what a statute looks like. When you're reading the statute, you are looking at several different things. Depending on kind of your approach to the law, you certainly want to look at the plain meaning of the law. And some people, some legal academics, are very much just about the plain meaning of the words in a statute. But sometimes you have to interpret or think about what was the intent behind it. So you read the statute as a whole. You want to look at, and we'll talk more about that, those concepts are a little bit more than what we need to get into right now, but it's about whether or not you interpret the law word for word, or if you interpret the law in more of a broad construction, and we'll talk more about that in research and writing. But look, pay close attention to where the words and the word or is used. Keep in mind, shall doesn't mean may, and may doesn't mean shall. Those mean two different things. Remember that when you start looking at the judicial interpretation of particular statutes, that courts are obligated to follow precedent from the higher court in their same higher court or courts in the same jurisdiction, that statutory interpretation binds the lower courts. So if you have a statute and then it is defined at a case level in a case at a court, then that statutory interpretation is going to be binding on the lower courts in that same jurisdiction. In most codes, there is an annotated version, and that's where you're going to get more meat when you do research. They're going to point you to more references regarding that particular statute, whether it be cases or law review articles or encyclopedia entries. I know a lot of this seems so theoretical until you actually look at the books. So don't worry, don't stress. We're going to get there when you get in research and writing. I've already said a little bit about legislative history research. That's when we're looking at what was the intent of the legislature, looking at committee reports, looking at floor debates, trying to find out what did the legislature intend when they passed this particular statute. And then finally, we may be researching administrative rules and regs, administrative law. It's a huge piece of our everyday life, and we can't ignore it when we are doing research. So remember, it is as binding as a statute, and it is a primary source of law. And if you're looking at federal rules and regs, you need to go and research in the Code of Federal Regulations, the CFR. Once again, all of these things we will talk more about in research and writing. This is just a taste, okay? You can now go to Chapter 8's presentation.